Hey there, welcome to inheritedland.com. This is your host, Jason. And today I'm with my attorney, Scott Royal Smith from Royal Legal Solutions. We have him here on the call today, and we're discussing this question of how should I set up my land estate to leave for my children? So we have all kinds of interviews and articles on this site, Scott, particularly helping clients that I bought land from over the years who find that they're in a very difficult situation where they've inherited land and maybe there's title work to clean up or a probate that needs done or affidavits of heirship, and there's some work in order to get the heirship and estate issues cleaned up just to be able to sell the property. So what our idea was today was to talk about how to prevent that for my future generation. What are the steps that a person could take who has some real estate and particularly thinks, I want to leave something that's easy for my family, and when I'm no longer around, I don't want to have them worrying about legal fees and court dates, but simply have a process where I leave them a blessing. So welcome to the call, Scott, and I invite you to share with us all your professional opinion and solutions.
Awesome. Yeah. Well, thanks, Jason. Of course, my name is Scott Royal Smith. I'm the owner of a law and tax firm called Royal Legal Solutions. And so like when it comes into what to do, right, and who needs to be focused on this kind of things, it's either, you're realizing that you need to make preparations for your own assets, or that you have parents that says, oh God, we probably should get things cleaned up because the unexpected can happen really at any time. And let's go ahead and make sure that we're proactive to take care of things, right? So there's a couple of things that you should be cognizant of to say, like, am I the right person to be able to have this taken care of and to like be able to take these steps? And the question is do you have anything, right? If you have children, you have to have an estate plan and make sure the children are going to be adequately prepared for. If you have assets and you're hoping those assets are going to take care of the people that you love in your life, you need to have something in place to be able to make sure they get those assets. If you don't do anything at all, what happens is everything has to flow through a court system where it all becomes public as part of the public record, where everybody sees everything, who's going to get it. People now start fighting with each other. Creditors come in and just people come in and start saying that you owe them money. And then they start filing claims and start stealing money essentially out of the estate from your like aggrieved family that's now having to enter into a month or a year-long court process to just sort out what are all the things that have to happen.
I know I've talked to many clients over the years that these processes can be a year, 2 years long. So I imagine already having expenses, the idea is I'm leaving something that should be able to help sustain and maintain my family and my heirs and be a blessing to them. It'll be tied up. If I have nothing that happens, but what about people that say, I'm good, I have a will? Is that the best way? We hear about
Same
wills.
Thing. Will is barely better than nothing at all. Because a will just says I have a document, but all the same stuff is going to happen. It's all going to have to go through a court proceeding called probate. Everything is still all pushed towards like the public record with what's there. Most of the time, unless wills are revised every year, they're out of date, right? So there's just a bunch of just wackadoo stuff that happens with those. And it's a lot of times because people like, they set up once and they're like, I don't want to look at it again, so having nothing at all is like the worst. If you have a will, it's a little bit better, but if you need a will that needs to be revised and looked at least every year, because even in a will, you still got to tell people like where the bank accounts are, what's the login information to Charles Schwab. You got to show them where they're going to get to that information. You got to show them like, okay, if something happens to me, here's the attorney you need to talk to that's going to help you navigate all of these issues. So it turns into be one of those things that like you really need a lot more support. And then what you really should have is something called a living trust. And inside a living trust is something that you can control all of your assets during your life. You can modify it as much as you want to. But with a living trust, what happens is it avoids the whole court process and it keeps everything anonymous. So that way it doesn't take like 6 months to a year for your family to get to their assets, if ever, because of how they can be locked up inside these court proceedings. Instead, they get immediate access to all of the assets. And then if you partner with an attorney with it, especially with a law firm that has redundancy in it, right? Because what happens if that attorney that you worked with before dies, retires, whatever, right? Are there other people that can pick it up to help the family navigate all of the legal structures and all of the legalities of everything that was set up, right? Because like the living trust is the plan to how to avoid the probate, make sure all the assets pass immediately to heirs, keep everything anonymous. But if you join that in with a law firm in the right way, then it becomes super affordable. And then there's already a lawyer that's in place to be able to help everybody navigate. Because like, listen, they're already grieving you, right? And now they're having to make complex financial decisions that really impact everything you thought you were leaving to them to help them take care of themselves. So set them up for success is what I always say. Like, are you setting up
Set them up
family for success?
Okay, so the idea is inherited land is our subject matter, but let's say I have a couple different properties. Maybe I have some business property. Maybe I have some agricultural land or recreational land. Maybe I also have my own home of residence. And of course, you might have some other financial assets as well. So you mentioned the living trust is the way to go, but what about these other elements? What do we do with the real estate? How does that fit? Does it all go under one trust? What's the best structure? Is there any way you could help paint that picture a little bit clearer for our listeners today?
Yeah, so you're really so like if I have clients that are business owners, right? They'll have their businesses and individual LLCs, like one LLC per business. Each one of those individual LLCs is all owned by their living trust, right? Because remember, the living trust is what's going to pass that business to their heirs without having to go through a probate process that comes with it. Then when you have the other piece of it is going to be looking at an asset holding company. So that's the company that's going to own everything, but it's not going to do anything. And that's what we really want for people to be able to see, that they will have all of their assets protected during their life, and they're all compartmentalized, they're all held anonymously. All of those ends up being held by an asset holding company. Now I'm going to show you right now, I'm going to pull up on the screen for you guys here as a diagram. And this is actually a diagram that talks about like our tax vehicles in particular, but this is what a complete protection structure like looks like, right? You'd have an anonymous asset holding company here that's going to hold all of your assets in a scalable format to make sure if you're ever sued, you lose nothing. So this is going to be all your land, your bank accounts, your stock accounts, primary residence, whatever the case may be, that you want to make yourself bulletproof to lawsuits. You hold down your asset holding company. Your other businesses that you own are these operating companies that they operate a business to bring in cash. And you can see here, it's all owned by a living trust, and then it flows through to you as an individual. So this is really the basics of like what it is that everybody needs is an asset holding company. And then that should flow to a living trust. Your asset holding company owns all of your stuff. And then if you're making over $150,000 a year, there's all bunch of like really cool tax things. But that's not the purpose of this call, but that's the structure.
Sure. So I'm understanding, and I see something there. I have an asset holding company. So like I said, if we had some business property, maybe some personal property or agricultural property, which would technically be a business, we have a holding company, and those assets are in, it says child series. What is that? Is that a type of company structure, or what is that?
Yeah, so we typically like to use either series LLCs or individual LLCs. Child series are these little baby companies that a series LLC can create. A series LLC is special that it's one company for you to form, maintain one bank account, one EIN number, 1 to 0 tax returns, but it can create an infinite number of what are called child series, and each child series acts like an LLC for liability purposes. So basically we get to create an infinite number of LLCs for free, and it doesn't cost us any operational headaches in terms of bank accounts and whatnot to do that. And then you can compartmentalize every asset you own. So if there's a lawsuit, like grandma fell through the stairs at like one of my rental properties, I only have that property exposed. I'm not exposed, and none of the rest of my assets are exposed.
Okay. So in a case that I own several pieces of land or real estate, like for instance, you mentioned single family rental houses. So a person owns some rental houses, they would have them in a series limited liability company there, LLC, that would open up child series A, B, C for each house, right? And then you're saying that for the simplicity of this, that company is held by the holding company, which is basically owned by my living trust. So I need to have a living trust that would benefit me personally and go on to my children. Now, how would I do that when that living trust is set up? Are my children then named as the beneficiaries, or how does
Yeah.
that work? Who's the trustee? These are terms that you hear a lot, and we aren't always clear on what they mean.
Yeah. So beneficiaries are just the people that get the benefits of the stuff. And then trustees are the people that have to administer executing whatever the people are going to get. And then the trust document says, here's all the rules of like what's supposed to happen. So you work with an attorney to say, here's all the rules of what's supposed to happen. And then I die, I want my wife or my husband to be the trustee to administer this, what's supposed to happen. Both of us die, it's my mom or my uncle or whoever, right? Those are all called subsequent trustees. That trustee then has to look at the trust document and say, great, I have to distribute all of these assets to whatever the rules are of the trust. And so they'll have an attorney. So this ideally is the attorney that helped you, since you're the one that just died, but helped you draft the trust. So that way that attorney says, here's how everything that's supposed to happen with the businesses and all of the assets in the holding company. And here's how the trust is structured to execute whatever the game plan is that was inside of the trust. And it's one person that looks at all of it to make sure it all works together correctly with it. But it's very, very simple, right? Is that during your lifetime, the living trust, you can modify it as much as you want to. When you die, like the trust calls, it becomes irrevocable, meaning it's locked in place at that point. And then the trustee will do whatever it says to do with all of the assets under the guidance of an attorney to make sure that they're doing everything correctly, exactly how the trust says. And then everything should run perfectly smoothly.
Okay. Wow. So let's just talk about only a piece of vacant land. So let's say it's not a business, it's just a piece of recreational land. Say I've inherited it, I want to hold on to it and just pass it on to my children one day. So I have my living trust, okay, and maybe there's no business or holding company here for this because it's not necessarily farmland or anything that produces any income. It's just, my 20 acres on the lake with a cabin, something I go to once in a while for a little hunting or recreational activity. So in that case, what entity would I put it in? Should I just put it in the name of my living trust, or how can I keep that in the right structure to leave that, so that number one, I have some protection while I'm alive, but it passes smoothly to my children when I pass away.
Yeah, that's a great question. I want to highlight for everybody that a living trust provides zero protection. Like it's zero liability or lawsuit protection. A living trust is as if you own the assets in your personal name. So a lot of times people will own assets in their personal name and they'll have a living trust. The living trust won't give you any protection places. Well, if you title assets in the name of living trust, it just means that now they're owned by the living trust and will get distributed in whatever way the living trust says to distribute them when you die. So we structure that out with like other asset holding companies underneath it and stuff because we want protection of the assets from lawsuits. So if I get into a bad car accident that exceeds the limits of liability in my car insurance policy, well, then they can't come after any of my stuff, right? And then the living trust owning that company that owns all of the stuff allows it to be protected and to pass. So the people that are the most exposed in the world are the ones that own assets in their own name or own assets directly inside of the living trust. Because for them, if there's a lawsuit, any one of their business deals goes sideways, anybody gets hurt on one of the pieces of property, if there's an email or a text message that somebody says that you lied to them or defrauded them, which happens all the time in situations you wouldn't even expect, they could lose everything they own. Because in this country, you can get sued for an unlimited amount of money at any given time. So the only way to really protect yourself is to have an asset holding company that owns everything. And then the best way to pass things to your heir is say, great, have that asset holding company owned by your living trust. And then I got one system that I operate, that all my like cash, my stocks, all my land, everything gets pushed into at least an asset holding company, whether that's an LLC or a series LLC. There's a ton of different options of what can make the most sense and how much those cost and what it is that you need. But that's the right way to do it, is living trust, asset holding company owns everything.
Yeah, awesome. So let me see if I'm following this because it's a lot of information, but it's great information. Thank you so much, Scott. You're very knowledgeable on this subject, definitely an expert in your field. And so the first and most important document I need is I don't want to have a will, I want to have a living trust. So if a person wants to set up an estate and leave an inheritance of particularly real estate or land to their children, they first of all need to have a living trust, which keeps it out of probate, sets the rules of how it's going to be distributed to their children, heirs, etc. Right? So I need the living trust. But if I have any type of assets, then I don't want to have them just within the living trust. I need to have some sort of a holding company set up, which will compartmentalize through these child series, right? And then I also notice it says land trust, A, B, C. Well, what is that? Is that something that's just over land, or what is that exactly?
Yeah. So the issue that comes into like any asset that we own, you see over here, like how this parent company, the asset holding company, is owned by an anonymous trust. That's because we want to have make it where nobody can find out what even companies we own. That's how we make it look like we don't own anything when people come to try to sue us. If we need to make private disclosures to banks or something like that, we can always do that and not worry about it for financing. But otherwise, we want to look like we don't own anything if people ever look inside of public records. Same thing here as it comes to like owning actual land or real estate, or even sometimes even placing like investments where you don't want your name to be on directly tied to the investment. Some of my clients even do this with their syndication and private placement investments. It's just about to being able to produce anonymity, information security. And so they're just called land trusts historically, but all they are is revocable grantor trusts. And what they do is they remove your name from the public record or from to create a shield of anonymity between you as the ultimate owner and your entity and wherever you're placing the investment. So that looks like, let's say like if Jason owned like a property at 123 Main Street, what happened is it would get deeded into a trust. And then what people be able to see is that this asset now belongs to the 123 Main Street Trust with Scott Royal Smith as the trustee of that trust. And then it also will get tied to the law firm address. So when they look into it, they say, well, I want to find out what assets Jason owns. Well, Jason's name doesn't appear on any of these assets, and so they can't find out that it's him. If they're like, well, we think he might own the 123 Main Street Trust, they look at it and they say, well, actually, it's that or that he might own the 123 Main Street. They'll look at it and say, actually, it's owned by this trust, and it looks like it's the trustee of this is this attorney, and we can't find any information about it because the attorney-client privileges prohibit us from being able to ask any information about the attorney, and it's only tied to a law firm address. So there's no information they can get about it. And the whole time we know how to structure that so that you can have that kind of protection where you can still also maintain full control of the asset. And there's some legal nuances that allow us to be able to mask everything for the client, but also then be able to allow the client to have full control of the property where we don't have any control of the property. So that way there's not a concern about people having to have too much trust for their attorneys, right? But that's what the land trust is about. It's about anonymity, right? Just like number 7A here, it's about anonymous trust, about how do you create anonymity? Because at the end of the day, if it looks like you don't own anything on the public records, it's very unlikely anybody's ever going to sue you. It's our first line of defense.
That's a good point. I hadn't even thought about that question, but the idea of setting up an estate for your own children and heirs is that you obviously want everything that you've worked hard for to actually get to them without frivolous lawsuits, ambulance chasers. And there are so many things that do happen and can happen. And oftentimes, particularly if you own real estate, land, house, rental properties, whatever, it is one of those things that people can actively see because it's in public record. They can go on the county GIS mapping websites and pull up who owns what property in this corner of town and see your name or information. So in this case, having it in a land trust, it might just say the 1220 Main Street Trust or the 20-acre Morgan County Trust. That's then owned by the Child Series LLC and the holding company and under your living trust. So here you're basically proposing to us, Scott, a way to smoothly transfer assets to our heirs, but also to protect them in our lifetime. And then they could even potentially continue that protection if they decided to continue to hold the assets, right?
Yeah. I mean, the whole structure and everything can pass to the heirs. And then this is where I think it really makes sense to partner with law firms that work in this way. I mean, we're the only one that I know about that services people that are like up to the 50 million mark. Most of the time, this kind of service only starts at like 50 million plus net worth for clients. Is that then you have like an attorney that says, well, cool, the asset protection structure and all the things like pass to the heirs. And it's the same continuity of the support relationship about like, how does everything need to run for the wealth management of like running all the companies and the tax and everything that comes with it. So really that's like this beautiful, smooth transition that happens that doesn't exist without that kind of service offering. Most of the time, what people do is that they put something together, they put it together 5 years ago, they end up dying, or 10 years ago, they end up dying. And then it's a free for all of trying to figure out where all the stuff is, who do they need to contact. Even then it's like, how does any of this stuff even work? Because they didn't set it all up. So they're having to learn a whole structure from the ground up, and it's terrible, terrible, terrible. So that's the problem that we're like really focused on solving, is protecting the wealth, helping people scale it during their lifetime, making sure that there's a smooth and easy transition to their heirs after their death, to make sure that what they care about most, which is their family and their legacy, being right and having those people taken care of in the right way.
Well, that's awesome. Very good information for all of our listeners today, Scott. A couple questions come to mind. You mentioned it's important to have an attorney set this up for you. You also mentioned that having a law firm that has set it up when you have your plan in place, therefore it would be easy for the attorney to walk your heirs through what steps need to be made. Of course, there's a bad name for attorneys out there. There are some sharks out there. And our first idea is, man, if I set that up, I don't want my kids to have tens and tens of thousands of dollars in legal fees on the back end when I pass away. I'm trying to leave as much as I can to them. If this is set up correctly, is it an expensive process to have the legal overview to disperse these funds and these properties at the end of it, or how does that typically look like?
Yeah, if you think being prepared is expensive, you should try not being prepared.
That is true. True.
I went to it. Negotiate on the front end, right? Like come to an agreements with whatever, if it's not us, right? Come to agreements with whoever you're working with about what is this going to look like. A lot of times what we see is we just do it as like a flat percentage of assets. Say, cool, it's a 3% fee, and then we handle everything for you that comes with it, right? And that way there's no need to negotiate over anything that's too crazy, right? About at the front end, that we can say, cool, do we all feel fair about that? Is that the way we want it all to play out? Let's just come to those agreements ahead of time. So that way we don't have to make those decisions later on. I would stay away from anything that's flat billable, right? Because,
those
like it just, even if they're super honest, right? People might not feel that way, like you can end up being really angry at people that are actually doing a really great job for you. Right. So I think that's the way we have it set up, is like, hey, it's a flat fee, 3%, as long as you're over a certain net worth, and then great. Now it's all handled, and, it's all pre-built in, all pre-negotiated.
Yeah. So I like what you said. If you think it's expensive to be prepared, try not being prepared. One thing, we have many other blog posts and articles here on the site that are basically designed after me personally having dealt with so many people over the years that wanted to sell assets they had inherited. But because these situations were not prepared ahead of time before their loved ones had passed away, there wasn't a proper structure of the estate, and it is very expensive. There are even cases where it would cost more to fix it than what the actual property is worth. So I've had to say no to some properties I would have loved to buy or help them sell just because they weren't prepared. So that's a great word for our listeners today. I do want to encourage you, everyone that's watching today, if you haven't taken the steps to set up this structure, I actually brought Scott on. He actually has set this up for me personally and my family, living trust, the estate, the holding company, the whole 9 yards. And it is a peace of mind aspect. We can all fix some other inherited land issues, but let's learn our lesson and let's leave a blessing to our children and grandchildren, to when we're no longer there, they remember us, the memories that we formed, and don't have legal frustrations to deal with over whatever we decide to leave them. So thank you so much, Scott, for your time today on this call. I really appreciate it. And for anyone that's listening today, if you scroll down here below the video on our page, there's a contact form. And so if you say, I'd like to sell some land that I've inherited, or maybe you're curious about how to set this up, and you'd like Scott or his team to be able to reach out and walk you through some of the steps and look at your particular case and situation, you could go ahead and put your contact information in the site, and we'll be sure to forward that to Scott and his team and have them reach out.
I can stop the recording if you want.